So welcome back to Introduction to U.S. Law. Today we're going to be talking about property law and then intellectual property law. So it might beg the question, what is property? Well, property is the right and interest in which a person has in lands and chattels to the exclusion of others. You might be asking yourself, what is a chattel? A chattel is something that is not real property, but personal property. We'll talk a little bit about that in a second. So one thing your book likes to talk about, and you've probably noticed that I'm supplementing some of the material in the book and not giving some of it much attention. These are the things I find probably most important to you in your studies that are coming up. But they do talk about first ownership. Like, what about something that has no owner? How does someone gain ownership of something that has no owner? And all law students get this case. It's usually the very first case they get, and it's about a fox. And the fox is running around, and this fox is really driving somebody crazy, and he's trying and trying to catch this fox, and he's putting in a lot of work, and then someone else gets the fox before they do. So how do we decide who owns the fox? Well, we use something called capture. So under the law, the first person to actually capture the property, and it doesn't have to be a fox, the first person to seize the property is going to be considered the owner, the first owner, the person who takes title, the right to own the property. In that particular case, the first man who had spent so much time trying to get this fox, and this was in England, I know they're crazy about foxes there, but the man who was trying to get it first said, I've put in much more work, I've put in much more effort, it should be my fox. And although the courts and the law do indeed appreciate putting in a lot of effort, the effort they most appreciate was the actual successful capture of the law. So we want to see that effort, but we protect property, and of course we'll see later on in today's assignment, we'll see we protect intellectual property as well as the tangible property we're discussing. So transferring title just means giving the ownership of property from ourselves to someone else. So transferring title is how we transfer the ownership of property. So let's talk about both real property and personal property. You can transfer title as a gift. You can just say, I would like to give you this property. Have my house. Have my fox. And a gift is an irrevocable transfer of property from one person to another. So that means once you have given something to someone else, you can't ask for it back. You can ask for it back, but you don't have a right to have it back. Maybe people will give it to you, but they don't have to. Once you've given someone a gift in the United States, it's irrevocable. The title now belongs to them. Sometimes we see this just, amongst friends, family. Also, when you're giving gifts to a charitable organization, you could be the donor and you give the property to the donee. But the donor must intend to transfer the property as a gift, and the donor must accept the property. So symbolic delivery is okay. Like if you're giving a hospital a new bus, you don't have to actually drive the bus up to the hospital chairman. You can do a symbolic delivery, show a picture, give the title, something like that. Now, personal property, you can just go ahead and give it. Like if you want to give a hospital an x-ray machine, you can just go ahead and give them an x-ray machine. But if you're giving real property, it has to be in writing. You have to have a transfer of title, and it's very formulaic. We'll talk a little bit more about that in a moment. But it has to be in writing when you're transferring real property, even for a gift. So a statement of intent to make a gift is not enforceable. And if you think back to our section on contracts, why is that? Because if I say, I want to make a gift to you, and you said, oh, I would love that gift, it looks like we have a contract. I've made an offer, and they've accepted it. But what's missing? Do you remember? That's right. It's consideration. There is no exchanged for bargain there. There's no, everybody's not giving something up. So there's no consideration. It's not a contract. So it's a gratuitous promise. And so if you want to see it through, you can, but you don't have to. So personal property transfers, you can get something called adverse possession of personal property. You can also get adverse possession of real property, which we'll talk about in a moment. And it's based more upon the diligence of trying to find the real owner. So you find property. You know it's not yours. If you're walking along the street and you find a Rolex watch, which you probably know is a pretty expensive watch, it's not yours. If you just keep it, that would probably be conversion, stealing that property. But if you try to find the owner and you're diligent about it, you may become an owner. Your right is only inferior to that of the actual owner. So after the real owner, it's you that's next in line. So if the property was abandoned and you find out later on the person said, this Rolex was a gift from my ex-wife, I hate her, I want nothing to do with her, I'm going to throw this watch away, I never want to see it again. If it was abandoned, then the finder is the actual owner of the property. That's the end of it. But if the owner was walking along, had it in his pocket, and mislaid it, just didn't mean to drop it out of his pocket, but just somehow dropped it on the property. Surprisingly enough, if they dropped it on someone's property, the owner of the property on which it is found has a superior claim to even the finder. All right. Now, if we find the owner, of course, it goes back to them. And that is a complicated process, but you should know that lost property is still the property of the original owner unless we can't find them. And you have to go through a lot of hoops to try to find them before it becomes yours, before you have actual title in mislaid property. Something called a bailment, and that's where you ask someone to hold property for you. And someone who's holding property for you has a duty to protect it. And this can come up in a number of ways. Maybe you're moving and from one house to another, and someone is going to move your real property, the personal property, the stuff inside your house, your couches, your clothing, everything, and you're asking them to move it from one house to another. They're going to have possession of your property. And that can look like they own it. So someone who has a bailment, like a mover, is holding it for another, and they have a duty to protect it and to protect your title to it. An accession, well, an accession is money you make from owning property. And so the owner has a right to any gain from the property. And one seems like an obvious kind of example of this would be if you own a cow and that cow is giving forth milk, then that milk is yours as well. So that would be an accession from the cow. We also see it in a lot of other examples as well. Now remember, there's many types of property. There's real property, and that means real estate or land. And land is always considered real property, and we treat it very specially in U.S. law. But it also includes the land and fixtures. So if you have a house on that land that is a fixture on the land, it's permanently attached to the land, that's going to be considered real property as well. And things in that house that can't be moved. Most dishwashers are installed permanently into a house. I realize you can take them out, but they'll be considered part of the real property. Personal property is anything that's movable. So a dishwasher, if you bought a dishwasher and you put it in the middle of your kitchen in the box, it's still going to be considered personal property. Once you affix it to the house, you put the plumbing in, you put the electrical in, you attach it to the cabinetry around it, then it becomes part of the real property. So property can change. The example I really like to give my students is if you have a piece of real property, an open lot, that's of course real property. It's the earth, the ground, all of that is yours. Unless there's a huge flood or an earthquake with earth shifting, it's going to stay right there. It's not movable. If you have delivered, a couple of hundred pieces of wood called 2x4s, framing wood for a house, and sheetrock, the thing you make walls out of, and paint, and asphalt shingles, and nails, and screws, everything you need to make a house is dropped on that land. That's all personal property. Once you put that all together and affix it to the land, all of that was formerly personal property is now considered real property. So anything that's not real property is pretty much personal property. And we'll talk about some intangible type of property later, and that's called intellectual property. So let's take a little look at the nature of property rights. You might think, it's my property, so that's it. But it's not really just a single right of ownership. That's of course important. But with each piece of property, you actually have a bundle of rights. You have the right to possess the property. So if it's yours, you have the right to possess it. And you have the right to use it as well. People can interfere with your right of ownership in general, or they can interfere with your right of one of these bundles of rights, as we call it. You have the right to exclude others from using the property or enjoying the property. and you have the right to alienate the property, and that just means sell it. You have the right to sell the property. Now, you may give someone the right to possess your property. You have a bicycle perhaps, and you say, you can use my bike if you like. You can ride it around all day. Just bring it back when you're done. I've given you the right to possess it and the right to use it, but I didn't give you the right to sell it. So you cannot go and sell that bicycle while I've given you the right to use it. And the general rule is you cannot convey to someone else a greater interest than you own. So if I have an interest in property that's not complete, I don't have title to the property, perhaps, and we'll talk about this later, I'm leasing the property. I have the right to use it for an entire year. If I want to alienate my interest, it's only a right to use it for whatever remainder of the year there is. I can't give a greater interest in a property than what I own. But we'll see the American law does allow for you to convey whatever of the bundle of rights you do have to another person. So let's define the interest in real property. So the owner of real property has an estate or an interest in the property. And these interests can be defined by how much control the owner has over the property or the duration of time. Remember, we can have a complete ownership where we have all of the rights that come with it, or we can go ahead and only have certain rights. How long we're going to have it, what physical space is allotted to us, and the way the interest is held. Is it going to be just me, or is it going to be me and my significant other? It's going to be me and 10 other people. All of these things are possible. We can change all of these. We tend to think of property ownership as being very discrete. It's my property and I have all the rights, but we can divide them up. So when we're looking at the degree of control someone has over a piece of property, we look at how much of that bundle of rights they own. There's something called fee simple absolute. And that's the greatest interest of all in control over property. You own all of the possible rights associated with the property. Any one of those bundle of rights, right to use, right to sell, it's yours completely. And we think everybody has this fee simple absolute, although most people don't know what it's called. And of course, the fee simple absolute, because it includes the right to alienate, is easily transferable by sale, by gift, or by inheritance. And we would usually do that with a will. And it's probably the most common ownership interest in land. But it's surprising, a lot of people will buy property and not understand they're not buying a fee simple absolute, and that's where trouble begins. Now we also have leases. This is when an owner of property conveys the right of possession for a limited period of time. And limited can be a long time. Like there are some leases, some commercial leases, that will last up to 99 years. And I just read about one that actually it was a law school that was leasing part of a YMCA's building for 99 years, and the lease finally expired. And so some people actually do see these leases all the way through to the end. Now, who is the owner? That's the lessor. The person who is leasing the building is called the lessor. They are the owner. They're also called the landlord. They're the ones who are leasing the building. And the person who is taking the property on this lease is called the lessee. Sometimes they're called the renter or the tenant. What do we call this interest in property? We don't call it a fee simple absolute. It's just a leasehold. So that's what we call a leasehold. And usually in American law, it is transferable. You can go ahead and assign your lease to someone else, and you can even sublease it. And so this is very common with commercial dealings. A lot of times we have consumer leases, people who are renting an apartment. They may specifically have this right excluded in their contract. But you can assign your lease, absent this provision, to someone else. Someone else becomes the lessor of the original, lessee, of the original lessor. Or you can be a subletter. You make a sublease. So you can say, okay, I am still the lessee, but I'm also going to lease part of what I have an interest. Remember, I can't convey anything greater than what I have, but I'm leasing it for 6 years, and I'm going to be out of the country for 1 year. I can lease it to someone else for that 1 year. So that's called a sublease. And unless the contract says you can't do it, then the presumption is you can do both the assignments, turning the lease over to someone else, or the sublease. With a lease, the owner retains a reversionary right to possession. So when the lease is over, the right to possession goes back to the owner. And sometimes the lessee doesn't leave on time and they have to enforce that right. They can convey title to the land without possession as well. So it can work the other way. So you can give title but say, I want to stay here. And there's different ways to do that. My favorite one is called the life estate. And this is not usually something that strangers do, but oftentimes family members will do. Like a mother who is older will want to give her property, her home, as a gift to one of her children, and she'll say, okay, I am giving you ownership of this land. It is your land from now on, but I reserve a right of possession, and this right of possession may be called a life estate. So as long as the mother is alive, she has a right to possession of the home, even though her child already owns it. That's called a life estate. So you may also convey personal property. It's possible as well, like cars, heavy equipment. This is common, that people will go ahead and give you the right to use these and retain ownership. And it's just a lease, right? You can lease a car instead of buying it. Heavy equipment is very attractive to some corporations to lease rather than buy expensive heavy equipment, because they can write off the money they pay on leases, but you couldn't write off, let's say, a loan on a particular piece of property. So a lot of tax benefits involved with leasing. Now, we talked a little bit about contracts and Article 2, but leases don't come under Article 2. They come under Article 2A, which we really didn't discuss in much detail. That's really for people who are going to be practicing law in the United States. So let's leave that to them. There are also use and access rights, and we also have something called trusts. Let's look at one of these use and access rights. The most common is called an easement, and this is a limitation on ownership rights. We'll talk about that a little bit more in just a moment. Then there's trusts, and with the trusts, we split the legal and the equitable title to something. So somebody owns the legal title, but the equitable, the benefits, all the rights from it, go to someone else. So it gets a little tricky here, but we have someone who is a transferor. We're going to transfer the title of property, and that person's called the trustor, or the grantor, or the settlor. But let's just call them the trustor, the person who's going to set it up. And then there's someone called the trustee. And the trustee is the person that the trustor has given the control and management of the property to. So the trustee, the person, has legal control over the rights of the property, but someone else still owns it. And there's usually, in these cases, a beneficiary. The beneficiary receives the benefits of the property, so they're the ones that get the equitable title. So now we have a couple people involved. We have someone who's giving away the property, and they're giving it to someone who is going to have all the legal rights, and another person who's going to have all the beneficial rights. Who would do this? This is crazy, right? No, this is very common for wealthy people, maybe someone like you, and your parents want to give you a great deal of money, but they don't really trust that you're going to do the right thing with it. So they give all of the money to a trust, and the trust owns the money. However, they appoint a trustee to give the beneficiary, the child, the benefit of all that money. And so it will usually have some sort of set of rules, like you will get X amount of dollars each year until you reach the age of, say, 25, and then you'll get the rest of it. But the child owns it, kind of, but not really. It's owned by the trust, and they're just the beneficiary of it until the terms have been met. So it's used to give someone the benefits of property without the burdens of ownership. Now, most children who have a trust would say, oh, it's no burden at all, feel free. But it can be used for other things as well. It can be used for people who are incapacitated. It can be used for corporations so that you are not burdened with ownership of certain property. Or it may be advantageous for tax purposes that someone has the benefit of property without actually owning it. So there are many good uses for trusts. The property that's in question, when we talk about real property, is usually defined by its physical limits, so the boundaries of land. You want to know how big your land is. But the limits they go to the four corners of the property, which may of course be very irregularly shaped. A lot of the deeds in the United States have very complicated boundaries, like the property extends all the way to the lake and on this side to the rock where Farmer Jones first laid his foundation. It can be quite archaic sounding, or they can be very, very exacting, like GPS coordinates. Okay, so we have the boundaries of the land on the extension of the land as we normally think about it, but the limits also include the space above the land and below the land. All right, so you have, in the old days, under the common law, a person's right in their property extended all the way up to the heavens and down to the center of the earth. We no longer say that. We know now that that was a long time ago, before there were airplanes and all of that. So now there's a reasonable height above your property. And this property can be very valuable depending upon the location. Actually, New York Law School a number of years ago sold its airspace above its building to the building people building a building next door to it, and they sold that airspace for I think $30 million, which is very valuable. So you might think of the space above your building as not being terribly valuable, but depending upon where it is, it can actually be quite valuable. Nowadays we have a new fight coming up. When airplanes first started flying over land, we had to question whether or not whatever the limit was in terms of the reach of someone's property. And now it's a reasonable height to accommodate airplanes. But lately we have a new technology that is really challenging the courts, and we're waiting for some new rules about drones. So drones fly lower over your property, and they can be quite a nuisance, and they can invade our sense of privacy for sure. So we'll be seeing new laws on that. Also under the ground. Under the ground, that's yours as well. And so people can't tunnel under your ground to make extra space for their basement. They can't tunnel under your ground to get access to your water. Now, there's a whole bunch of special laws called riparian rights we won't get into in any great detail, but the laws about water as property are very complex as well. So we talk about the boundaries of land, all around us, up and down, and now the physical structures on land. As I mentioned before, if you have a building on the land, a house, a building, that is going to be part of the real property. The lumber that went into it, once you make it into a house, that lumber is no longer personal property, but real property. Even a carpet. Most carpets are, either glued or tacked into the floor. They're all considered real property once they're affixed. Now the space inside buildings, of course, belongs to the person who owns the property. We'll see a little bit later on, we have different types of ownership for condominiums, and we'll talk about what that means in terms of ownership a little bit later. Property can also be defined, of course, by time. Now, continuous ownership, fee simple, is an indefinite amount of time. It's until something else happens. If you own property in fee simple absolute, you own it for an indefinite amount of time until something else happens. But there are many different types of leaseholds. We saw one already of limited duration, but they can be renewable. The leaseholds, you might have a lease for 5 years. If the parties both agree, you can continue to lease it for another 5 years or whatever terms you want. So they are of limited duration, but you can make them renewable and keep a lease for many, many years. I talked about life estates. Remember, the life estate, you have the right to be there, and it terminates upon your death. These are actually still popular, or they were at least until a few years ago in France for strangers. People would buy property and give the person who owned it money, and then they knew when that person died, they would get the full use of their property. And there was a woman, I think she gave a life estate when she was in her late 70s, and she actually lived to over 100. And the guy that bought it was, his children were already grown up. He thought he was going to get the property within 5 or 6 years and didn't get it. So it can be a real gamble. You might get it, the next year, but you might have to wait a long time. They're not really popular with strangers. Usually they're for family members who want to pass on their property. There are also future interests. So you can grant property to so-and-so for 3 years, and then it becomes the property of someone else. Perhaps you are giving the right to property for one of your children who is bringing up children, but once the children reach a certain age, you want that property to revert to someone else who will have better use of the property. And in the United States, it's becoming popular again, although not as popular as it once was, are timeshare interests. You can buy a piece of property with hundreds of other people, and you each share a portion of that property. So you each decide who will have it on certain days. People like to do this with vacation homes in nice places in the United States where you own 1/100th of a piece of property, so you get 3 days a year that you can have use of the property. They are a big problem for people who get involved with these timeshares if they're not run properly or if they're not funded properly. So they can be fun, but they're also rife with potential litigation. So property can also be defined on how the interest is held. And by that I mean you could be the single owner, and that's the easiest. One person, and one person can be, in the United States, as we'll see coming up, can be a corporation. A corporation is considered a person, even though it's not a human being. Person is different than a human being under U.S. law. But one person or entity can own a piece of property. It can be a corporation, a trust, or something else. We also have what's called a joint tenancy, and that's when two or more persons hold an undivided equal share of the property. If you hold it jointly with one other person, you each own half. Jointly with two other people, you each own 1/3. And here's the weird thing about a joint tenancy, is you all have the right to use the whole property. It's not a particular 1/2 or 1/3. Joint tenancies are really common with married couples because you both share the whole property. And the really important part for a couple is the next part, which is the right of survivorship. The right of survivorship says at the death of one of the joint tenants, the surviving joint tenant is the sole owner, and they don't have to do anything else. They don't have to pay any money. They don't have to go to court. That's how it works. Joint tenancies are really mostly valuable to married couples, but anybody can use them. Now, they can be petitioned by a court or by sale of an interest by one party, and when that happens, when we say, okay, the joint tenancy wasn't going that well, people are having fights, then they go to court to separate it, then we're going to go ahead and petition it. So if you have let's say you have a duplex that you own as joint tenants. And a duplex, for those of you who aren't aware, is a house that is one building but has two separate living areas. Maybe they're apartments, maybe they're little townhouses, but they're completely different living structures. And if this would be a really easy way to partition a joint tenancy that's becoming not joint, and we can go ahead and have a court do that. It becomes then a tenancy in common. They both share a common interest, but they each have a part of the property that can be defined, unlike the joint tenancy where it's everybody owns the whole thing. There's also something even better for married couple called tenancy in the entirety. And it's the same as the above, but again, there is no right to divide the property. So you can't do that. You can't go ahead and after a fight divide it up. Only by mutual agreement or by court order in a divorce. So those are the three. Joint tenancy, most common. Tenancy in common is also available. And then the tenancy in the entirety, which is the largest protection for married couples. Tenancy in common, the reason why couples don't favor this, but unrelated parties sometimes do, is because there's no right of survivorship in a tenancy in common. If not specified when you own property with someone else, if you don't say this is a tenancy in the entirety, even if you're married to that person, if you don't say this is a joint tenancy, then the court will assume, if you fail to put any language into the transaction, they will assume it's a tenancy in common. Now, personal property, I'm going to talk a little bit more about that. Remember, that's all property that's not real property or a fixture. So remember my dishwasher example? It's personal property when it's sitting in the box in the house. When it's attached, it really becomes part of the land. Technically, though, it's called a fixture. It's treated like part of the land, but it's technically called a fixture. So most goods, things that aren't tangible like stocks, patents, copyrights, bank accounts. These are all property. These are all personal property. They can have multiple owners. For example, remember the joint tenancy that we talked about with real property? You can have a joint tenancy in a bank account. And that's where perhaps a husband and wife, I don't want to discriminate, a wife and wife, a husband and husband, share the whole ownership of the whole account. And the great thing about that is one of them, it's not great when they die, but if one of them did die, they're both protected. They don't have to try to get a court to allow them access to the money. All of the money belongs to both of them. So we also have the right of survivorship there as well. Doesn't have to be a bank account or land. Two people can own a car as long as you set it up that way. So there are other rights that are included in the real property as well. I mentioned one of these before, the right to quiet enjoyment. So if you own the property, you have the right to possession and control over the land. So you can exclude trespassers. Someone is coming across your property, you have the right to not just possession, but to enjoy it. If you want some privacy and that's interfering with your property rights, you can exclude them as well. Another way that your enjoyment could be somehow diminished is perhaps the neighbors next door they decide to raise pigs in a city place and the pigs make an awful odor. They are intruding on your right to quiet enjoyment. You actually have the right to take them to court to try to get them to stop what they're doing. Now, you're not always going to be successful. It's very complicated, but you have the right to protect against nuisances like that as well. Unless there's something in the deed that says otherwise, oil, gas, and mineral rights are part of every deed. They're included in the ownership of the land, but they can be separated. And in many parts of the country, as a matter of fact, where Texas A&M is located is in an area with a lot of natural gas, and there's quite a bit of oil in Texas as well. Sometimes when people sell their property, they will retain the oil or gas rights, or maybe all the oil, gas, and mineral rights. And that's perfectly fine. They can do that. Some people don't want to sell those rights because they're worried people will come on the property later to extract those oil, gas, or mineral rights. And that would be me. So you can sell them. You can also lease them. So during the time when natural gas prices was very, very high, gas companies would approach homeowners and say, we would like to lease your property rights for your oil and gas and minerals for the next 5 years and pay them a certain amount of money. And a lot of people did that. And it was actually fairly lucrative for a lot of people. And some of the oil and gas companies never even actually extracted anything. So it was a nice little benefit for them. I mentioned this before, water rights, very complicated. There's something called riparian rights, and it's the right to take water out of the environment. So let's say there is a river or a creek running through your property. You may have the right to take some of that water. But what happens if you take all of the water, or you dam that and it no longer flows downstream to your neighbors? Very complicated. We're not going to get into that in this particular course, but if that ever happens to you, you need to find a good lawyer. There's also littoral rights, and those deal with the lakes, seas, and oceans. You may have rights if you have property that bounds a sea, a lake, or an ocean. Now you can have consensual limitations on ownership. This is where both parties agree that there's a limitation on the ownership. And I talked a little bit about this before, and that would be like an easement. What is an easement? We didn't really get into detail on that. That's the right to use part of another person's land for a specific purpose. It's not an ownership interest, it's the right to use it. And a typical easement might be you give the gas company an easement to run gas pipes through your land. You've given them permission to do that. They don't own the land, but you've given them permission to use that. There's also, you can have an easement with your next door neighbor. As a matter of fact, I have this particular easement with my next door neighbor because whoever built our houses 100 years ago decided there wasn't enough room for each person to have a driveway. So they built a driveway half on my neighbor's property and half on mine, and we share it. So I have an easement that allows me to drive on the other half of that driveway, as does my neighbor have an easement to drive on my half of the property. And it works out really well when you've got a good neighbor. There's also something called a negative easement, and you can agree to these with your neighbor. Like I'll have an agreement with my neighbor not to build my house any more than 2 stories high. These are very popular in places on the waterfront. So you buy property from someone and their house is behind yours, and you agree to have an easement on your property where you will not build your house more than 1 story high so that you are not obstructing the view of the person who's selling you the property. You can have a negative easement that says, I will not build a fence. For some reason, the person doesn't want to have a fence between the properties. These easements can be perpetual. They go on forever until you agree to stop it, or they can be for a specific period of time. Maybe the person doesn't really care who comes after them. It can be until they sell it, until they die, for 5 years. It's up to you. And they can be terminated if both parties agree. They don't go on forever. There's also something called a license, and that's very similar to an easement, but a license can be revoked at any time. Now, licenses are not covered by the statutes of fraud. Remember the statutes of fraud? Do you remember what that's about? That means that certain contracts have to be in writing. Easements don't have to be in writing. We favor that. We have some easements that just happen because of common practice. But licenses definitely are not covered by the statute of fraud, and they can be oral, so they're very difficult to prove or prove you don't have one. So revoking them is very easy. So it's easy to get out of one. There's a number of cases where there was an intent to create an easement and it failed because it wasn't written down. The courts sometimes will treat that as a license. And that's okay. The problem is it can still be revoked. There's something called a covenant. And a covenant is really a promise by a landowner to do or not do something. It's respect to the use of their land. Usually we find this in subdivision agreements. And everybody in the subdivision agrees that they'll have their mailbox in a certain place so the neighborhood looks nice or something like that. The idea, it's building and use agreements that are going to have some sort of ensuring of neighborhood uniformity. People want their neighborhood to look a certain way. Some people think that's terrible, but some people like that, where every house looks the same and people know you're not going to build your house right on the street, that everybody's going to have a certain size of front lawn. So when you look down the street, you can see all the way down the street, and people won't be building houses anywhere they want. They have to be so many feet off the street. That's very important for some people. So these covenants are the kind of promises that you make in that subdivision that you'll abide by these rules. Now, I have to say this. I mentioned a little bit about this previously. We have a history of racial unrest in our country, and a long time ago we had people putting in covenants not to sell to people of a certain skin color, covenants not to sell to people who are of a certain religion, and they were perfectly legal when they were written, and they've all become against public policy, and you can't do that anymore. But it's part of our history that I'm not proud of, but you have to face it, and we move on. We're doing much better, thank you. There's also something called equitable servitude. That's kind of a mouthful. This is similar to a covenant, except they provide for an equitable remedy rather than damages. Do you remember the difference between equitable remedies and damages remedies? Damages remedies are always going to be cash. So whatever damages you suffer, we reduce it down to money. Equitable remedies are when a court compels you to do something. So equitable servitudes tell us that you'll be actually forced to do something. So it's usually going to be by the order of a court. It's going to be what they call an injunction. The court's going to order you to do something, like tear down the fence that you weren't supposed to build, or you promised you wouldn't add on to your house. They're going to make you take down that addition. These are very strong remedies. Courts don't like to use them, but if you have agreed to these equitable servitudes, then you can be required to do those things. Now, it does not require the conduct to be binding on future owners. It can, but it doesn't have to. So we can have a big mix of covenants and servitudes, and we can be very creative as to how long they go and when they sunset, when they're no longer going to have any effect. So we've been talking about ways people can agree to have limitations on their property ownership. But there are also some limitations that arise because of operation of law. And my favorite one, and law students love this one, I hope you will too, is adverse possession. This is where you can gain legal ownership without consent of the owner of the property by physically possessing the property for a specific period of time. All right? It's not easy, all right, and it's usually a very long period of time. Some states it can be as few as 7 years. Most states it's like something like 20 years. And this is where you have to actually occupy the property for the entire time. It has to be hostile to the owner's interest. It has to be clear you're doing it, and it has to be open and notorious. There's no hiding it. Everybody knows what you're doing. It has to be exclusive and continuous. So a very common example of this would be with a fence. So if I put my fence on someone else's property and the neighbor knows I did it, and I'm very clear that I am putting my fence right here on this piece of property. I don't have to say I know it's your property, but then I start using that land as if it's my own, and the other person doesn't say anything about it, and this will fulfill all the requirements. So after that period of time, that property actually becomes mine. Now, it's usually a long period of time, and any time during that period, if the other party says, wait a minute, that's my property, and they actually have the right to remove that fence. They probably won't, if they think they might be wrong about that, but they can remove that fence and then go ahead and tear up the garden, whatever you put on there. And then if the person comes back the next day, puts the fence back, the time limit starts all over again because it has to be continuous. So on Stanford University, they have a special gate that they leave open to the public so the public can drive through their campus, because it really saves people a lot of time getting from one side of town to the other. But once every 3 years, just to make sure, they close that gate and they don't allow anybody to go through the property, so that won't become it would be an easement by adverse possession. So they let everybody know they're doing it for that very reason. So no one will ever say, well, we've been openly hostile and all this for many, many years. Stanford always closes it down to make sure this doesn't happen. There are also other operations of law like easements by prescription and by necessity. And these can be obtained similar to adverse possession, like the Stanford story. It doesn't mean that you are going to own the property, but if you keep using that property for enough time, then you may get this like adverse possession, not an ownership, but an easement. Easements are normally done, as you recall, by contract, by negotiation, but you can get an easement this way as well. In my own example of my driveway, if I didn't know that that was my neighbor's property, or that my neighbor didn't know that was his property, and I continued to drive over for many, many years, he would no longer be able to claim that I can't drive on his property because we've been doing this almost like an adverse possession of that easement, similar to the adverse possession of ownership of property. There's also something called mechanics liens, and this is when builders or contractors aren't paid for their work. They can create liens against your property. The lien will be a right to payment. So if you want to sell your property, there may be a mechanics lien on it. And so mechanics liens have to be recorded at the property office. So wherever the titles are kept, usually in the county property records, the disgruntled builder or contractor or a plumber or electrician, someone who did work on your house, will say, you never paid me the $3,000 you owe me. I'm going to put a mechanics lien on your house. And does that mean you have to pay it? Not right away, but you should pay it, because when you want to sell your house, or if you want to refinance your house, that will show up on the deed. And you won't be able to sell it without clearing that lien, or the person buying it will deduct that from the price and pay it off. So eventually you'll have to pay it off. You can also litigate against those mechanics liens, but you must do something with them. So we've been talking about the rights, privileges, and benefits of property. There's also some duties to owners of real property as well. Remember I talked about quiet enjoyment of your property? You have that right. Well, you also have a duty to refrain from doing anything that's going to create a nuisance and interfere with someone else's quiet enjoyment of their property. So activities that adversely affect the adjacent owners, like if you build a factory and it makes a lot of dust. Maybe you make cement and the cement dust is wafting off onto your neighbor's property, you have a duty to refrain from that type of activity. And a court can actually order judicial abatement. And that's an injunction, and they're going to be telling you, stop doing that. With something like that, money damages aren't really going to satisfy. And so this would be a case where injunctive relief would be probable and even preferable. Because if someone gave you money to clear up the dust on your property and there was just going to be more the next day, it would be kind of a useless remedy. Cases analyzed considering both the nuisance and the degree of its interference. So if you have like some dust coming into your property, it's kind of, it's kind of a pain in the neck. You might have to brush off your car once in a while, versus the fact there is so much dust that you can't remove your car. You have to shovel out your driveway from all the dust. We're going to look at the difference between someone who is just a mere nuisance and someone who eventually is, because there's so much of this dust, they're actually trespassing on your property. So these are kind of difficult cases. Luckily, as non-lawyers in the United States, you're not going to have to deal with them. So the context is really important. Remember my hog farm example where the neighbors next door decided to raise pigs and hogs and the smell was just terrible? Well, if that was in the country, it might be seen as less of an interference with property as it would in a crowded city, of course. There are usually also laws about raising pigs in the city. So we also have within cities industrial areas, commercial areas, residential areas. And so if it's appropriate for where it's at, it will be considered less of an interference with property. So continuing with the duties, we have duties to people who enter property. So if we have property and people are coming onto it, we have a duty to protect them from conditions on our land. And there's something called the trichotomy. You don't have to worry about what that's called. But we break down land entrants into 3 different groups. We call them invitees, licensees, and trespassers. An invitee is someone who's on the land for business purposes. So if we own a store, everybody that comes in, whether or not they're buying something, whether or not they're just looking or stealing our ideas for decorating, if we have a business, everybody that comes on is an invitee. And we owe them the highest duty of any entrant. So if you're a homeowner, you can still have invitees even though you're not opening your house to the whole public. If you invite someone in for a business purpose, like a plumber or a banker to refinance your house, for whatever reason someone is at your house for business purposes, you have to treat them like an invitee as well. And again, we owe them the highest duty that we owe any entrant to the land. What is that duty? We have an affirmative duty to inspect our property to make sure there are no dangerous conditions, and if there are, we have to either fix them or warn the invitees about that danger on our property. We also have something called licensees. Now for businesses, there's probably not going to be many licensees. Licensees are more for homeowners, and those are going to be our social guests. And people mix this up a lot. First-year law students mix this up a lot because invitee sounds like, oh, I was invited over to tea, yet that makes you a licensee, because invitees are the business people. Licensees are social guests, they are neighbors, people like that. We have no duty to inspect the property for licensees, but we have a duty to warn of any dangers that we know about or make them safe. So one of my favorite examples is a person has a house where the floor is pretty consistent throughout the house, and then at one point, going into one room, the floor drops down about 6 inches. And the floor is an interesting pattern that completely hides this, so you can't see it. And you've tripped over it yourself many times. Your kids used to do it until they learned. And you have someone come over to your house and you don't warn them about this known danger. They trip, they fall, they break their hip, and you would be responsible for failure to warn them. And finally, the last group of entrants who we owe the least amount of duty is trespassers. Okay? They have no right to enter our land. Anybody who enters your land without your permission is a trespasser. But here's the thing, we still owe them a minimal duty. You still have to keep your property free of unreasonable dangers a trespasser would not expect. So you can't set up a trap for trespassers that would hurt or kill them on your property. There's a very famous case called the Spring Gun case, where someone was really tired of teenagers coming onto his property. He had a little hunting shack in his property. And teenagers would come in, they would drink beer, they would rip things up, and then they would leave the place a mess. So he said, I know what I'll do. I'm going to set up a shotgun at the door, and when they open the door, it will be attached to a string which will pull the trigger and shoot them. You can't do that. It's an unreasonable danger. Plus, you may recall, you can't use deadly force to protect property. So he was indeed found liable for what he did. So you can't intentionally create dangerous conditions on your property, and if there's dangerous properties you know of, you must make sure that you take care of them if the trespasser wouldn't see them. If it's open and obvious, you don't have to do anything. The trichotomy is waning in favor. Courts are now starting to use a reasonable standard, what is reasonable versus these three standards, but it's still in use in most states. So we've been talking about the duties that landowners owe to entrants. We have special duties for people who own like a hotel or a motel, and these are innkeepers. We talked about this a little bit in torts, you may recall. And this dates from the Middle Ages. This is nothing new. We're supposed to protect guests from the intentional acts of others. And it makes sense because when you're in a hotel or a motel, you are, going there usually at some point to sleep. And so while you're asleep, you need to be better protected. We also have liability for environmental cleanups that are assessed on owners of property. State and federal laws mandate the cleanup of any hazardous waste that an owner brings onto the property. It imposes costs on those owners and those who contaminate the property. And it may extend to people who are just creditors, just not actually doing the hazardous waste disposal, but are actually funding the operation. So there's sometimes a defense available for subsequent purchasers if they looked at the property, they had inspections done, and whoever did the bad deeds with hazardous waste was very careful to cover up their tracks. Then they perhaps would not be liable. But generally, liability follows the land for these hazardous waste cleanups. Now, a lot of people don't like this at all, but there are, of course, property taxes on the ownership of real property. Every state and most municipalities impose some sort of taxes on real property. These taxes are used to support community services. Sometimes, like in Texas, they will actually tell you this tax is for the schools, this tax is for government, but they're used for community services, and they're usually due at least once per year. Some municipalities have them due quarterly, but usually once a year. And it's based upon the assessed value of the property times the tax rate. So if the tax rate is 0.06%, we would take the value of the property and multiply it by that to get someone's tax bill. Now, some problems that come up are that jurisdictions may be behind in their assessment. Some neighborhoods may have become much more valuable, but the city hasn't changed their official assessment, where other people's property has been assessed and brought up to today's standards. Also, when you sell your property, it's kind of hard to argue the property is not worth at least what you paid for it. So people who've had their property for a long time may be able to sneak by with lower assessed levels. The rates that municipalities charge varies widely by location. Some places have very, very low taxes. Some places some people would say are exorbitant. And it has to do with the services that are available as well. So richer communities generally pay more tax dollars. And remember, we're funding schools and other services. So sometimes the rich communities, their children get much better schools than other communities do. Some people see this as a terrible inequity. Other people see it as, well, we're paying more money, our kids should get better schools. Our kids are better. I'm not saying their kids are better. So it's a big discussion. All right. So in regulating land use, there are some federal laws about land use, but they're mostly local. And the most common type of government regulation on land use are zoning laws. So you're dividing up a municipality into zones that decides the use of each part of that property. So we can have a residential area, a commercial area, and an industrial area. And these do not offend the U.S. Constitution if they're used to promote the health, safety, morals, and general welfare of the community. A lot of big cities in the U.S. have very strict zoning laws. Here in Texas, Houston has almost none. So you see neighborhoods of great variety of types and uses of buildings. But it's up to the community to decide what their zoning looks like. Municipalities can also, and most do, have building requirements. You usually have to get a building permit to build a building in any given jurisdiction. So the building permits will show what you're planning to build, how you're planning to build it, and they can see if you're complying with the building codes of that municipality. So building codes are, of course, to protect the health and safety of people, and so they want to make sure you're not just throwing up a building in a way that could potentially harm its inhabitants. And it varies greatly by area. As a matter of fact, in California, we have some of the most strict building codes because California has a lot of coastal areas and a lot of earthquakes. So there may be requirements in earthquake-prone areas that you wouldn't find in some area of the country where there are no earthquakes. There are also subdivision regulation. And remember, subdivisions are usually not municipality decisions. They're usually private subdivisions. Someone buys a big piece of land, subdivides it, and sells it piece by piece. And they're kind of responsible for the shape of that community. And remember, we saw some of those rules that you can agree to keep your property looking like everybody else's. But the municipalities still have some say in how they build those buildings. They have to follow the building code, and the builders must show how they're going to connect that subdivision to existing infrastructure. How will they get the owners of the properties access to electrical hookups, to water and sewage, or will they have a different type of waste system? So although it may be a private subdivision, the government still has quite a bit of control over how the property is run. And occasionally the government will actually take ownership of someone's land, and that's called eminent domain. So the government has the power to take private property for public use. Generally they do this by condemning the property that they need for a public improvement. And this was really common in the 60s when they were building our big interstate highway system. They would condemn a whole neighborhood and plan to put a superhighway through there. And so they would condemn it and then tear down those houses and build a highway. Now, luckily, the U.S. Constitution put some limits on the government's ability to do this. The Fifth Amendment requires they can't be taken for public use without just compensation. And generally, my personal experience is people who are having their property taken by eminent domain, in order to put off long court battles, the government usually pays actually a little premium for these properties to make sure it goes well. So it has to be for public use. Now that's usually fairly clear. If you're building a highway, that's obviously for public use. But transfer of property under eminent domain sometimes can be from one private individual to another. And some of the work I did when I first became a lawyer was to determine whether or not a eminent domain taking had been given way back to a gas company. And why would a gas company, a private entity, be allowed to use eminent domain? Well, they had the right in the state of Connecticut to run gas pipes through other people's property. And they actually were doing a taking, because normally you would have to ask permission and get permission for that easement or for that sale of that particular piece of property, however it is they're going to use that property. And in Connecticut, in the early days when they were putting in gas pipes, the government actually did a taking. They allowed the gas company the power of eminent domain to run gas pipes over people's property. But those are usually uncontroversial, even for gas or electric types of utilities. A little bit more controversial, but still not that controversial, is building a stadium. And you see this all the time. We build a stadium for a private team, like a big football team, and we might have to condemn land for it or for its parking lot. Still seem somewhat uncontroversial, even though the benefit is going to go to the owners of a private sports team. What's really controversial is something like Hawaii has this redistribution plan where they're trying to make sure that the native people who were kind of forced out of their property get some of their property back. Seen as very controversial. And so they have a whole urban renewal economic development plan that was seen as overstepping the bounds of eminent domain. And again, in all of this, there has to be just compensation, what a willing buyer would pay a willing seller. And again, it's not part of the doctrine, but from what I've seen in eminent domain takings, the government is usually a little generous to make sure there's no litigation.